Alright everybody, welcome back to my channel. Hope you guys had a good holiday. I know I didn't do a video over the holidays. I'm going to try to kick off 2 or 3 for today and tomorrow. But before I start on the continuations of shareholder liabilities and stuff and shareholder rights for American Jurisprudence under Business Trust, Volume 13, the upcoming books that I will read after this is going to be elementary law. So this deals with fundamental law, your natural rights and so forth, the history of law, the natural law and statutory law, municipal law. Let me see some table of contents here. Here, like this, book number 1. There we got introduction of law in general, of international, municipal, state, federal, unwritten, written, maxims, statutes, public, private statutes, natural persons, everything, equity, maritime law, of private rights, of the right of personal security, personal liberty, right of private property, and so forth, right? I'm not going to read through this whole book, right? There's almost 500 pages. I have 4 of these, at least 4. At least these are the ones that I want to talk about. So I'm going to pick and choose, but the topic is going to revolve around citizenship and natural rights, your private right. So throughout these 4 books, I'm going to go back and forth for different, from case law to whatever interpretations that this author has had for it. Another book that I would like to do is this one. For those of that are prepared for this, right, or who have a foreign estate or trust, right, is a tax management thing. This might be a webinar. I might do it for like $25 or something ahead, but this is at least a 2-day webinar, and it has 3 books that you would get with it. One of them has a template of a trust in, the Republic of Oceania. A lot of provisions that you could do. It has up to, I think, 10 worksheets in the back, maybe more. Yeah, 12 worksheets. So it's up to y'all, whoever wants to participate in that. This will be a very good book to read, though, and understand, though. So it has detailed analysis, foreign trust, and U.S. taxation, what constitutes a foreign trust, or even a foreign estate, right? That's all in here, too. So let me know if you guys are interested. So to continue on American jurisprudence, this is going to be Section C, liability for trust debts and obligations. This is pertaining to, of course, the beneficiaries. So Section 34, generally. According to the generally accepted view, that is the control test, the status of a business trust for the purposes of determining the liability of the shareholders depends upon who has the power of control over the business and property of the trust. And this is what we learned earlier. Powers of corporation, powers of partnership, powers of association, whatever, right? If the ultimate power of control is vested in the trustees who also hold the legal title to the trust property, the organization is treated as a true trust rather than as a partnership, and the shareholders are not liable for the debts or contractual obligations incurred by the trustees. As stated in some Supreme Courts, if the organization is actually a Massachusetts trust or a true trust, the shareholders are not liable for its debts. But if the shareholders have the power of effectual control over the trustees or over the affairs of the trust, the concerned business is regarded as a partnership, and the shareholders are consequently liable. Where the ultimate power of control over the property and business of the trust is vested in the shareholders, they are liable as partners for the debts of the trust, even under the statute expressly authorizing the creation of a trust to carry on any lawful business designated in the trust instrument, since such an organization is not a trust but a partnership. So you would have to read the context of what those cases are. But they all said the same thing. Powers in the beneficiaries or the shareholders to control. In a few jurisdictions, the shareholders of a business trust are liable for the debts of the trust, irrespective of the question of their control over the affairs of the trust. So it doesn't matter what you wrote in the document, right? They're still held as partners for whatever reason in that jurisdiction, right? The shareholders have been held liable as partners for the debts of the trust where the business of the organization was carried on under a name in which would indicate that it was a corporation. So if you're a trust, then you write what? LLC or incorporated at the back of your name, knowing damn well all it is a name, right? But nonetheless, you used a fake name that would give somebody the interpretation that you're a corporation. Would indicate was a corporation and the shareholders did not hold themselves out as operating under a trust agreement. Even in a jurisdiction where by statute shareholders are generally exempt from personal liabilities for the debts of the trust, persons who associate for the purpose of forming a business trust but who fail to perfect the trust are liable as partners for goods purchases on behalf of the association. And in a jurisdiction which regards business trusts as imperfect corporations, it has been held that the shareholders of such a trust are in a position of persons who begin but never complete the organization of corporation, and as such are liable for the debts of the trust. But this, you got to remember, this is just in your indenture, meaning you are writing down, limited liability in your indenture. This does not constitute a specific contract, right? Meaning the trustees contract with someone and they write limited liability for themselves and shareholders. Okay, well, this is a specific contract that the guy just signed. That's different than having it as a general provision. That's probably why they tell you write it in your trust agreement and in every contract. So the fact that credit was not extended to a trust on the financial responsibility of a particular shareholder, or even that at the time of the credit was extended to the trust, the creditor did not know that a particular shareholder had any connection with the trust, does not prevent the creditor from holding such shareholder personally liable for the debt of the trust is regarded as a partnership. Former shareholders are not liable for debts contracted on behalf of the trust after they have ceased to be shareholders. That should be a given. And this rule has been applied notwithstanding the fact that there was no transfer on the books of the trust as required by its rules. In the absence of a showing that the creditor at the time of the debt was incurred knew of the membership of the shareholder and relied thereon in extending credit to the trust. One who inherited shares in a business trust held by the court to constitute a partnership prior to the time when the note was executed, and who asserted his ownership of the stock and recognized as its owner by the trust, participated in the business as received dividends on the shares upon the time only 1 month before the debt was incurred, was liable for it. So he basically got some shares, did everything you could think of that would make him a trustee or whatever position he is, right? Participated in whatever, and now you know why he got held liable. He had too much power. However, it has been indicated that a person inheriting shares in such a trust after a time when the trust incurred an indebtedness will not be personally liable for the debts, and that in such case the creditor remedy would be restricted to the enforcement of a lien against the shares so inherited, where the control over the trust, over the business and property of the trust is vested in the trustees and not in the shareholders. The executor of the deceased shareholder may continue to hold the shares without rendering himself liable for the obligation and indebtedness of the. So this is like even a will, right? You have a will, you have, for whatever reason though, you have shares in of a corporation or in this case a trust, and at your death you have an administrator, an executor that's managing your estate to do whatever to close out your affairs. He's not going to be obligated for any debts that you incur as long as the trustees have full control in the writing and in their actions. And so that third person who just contracted in because of a will is not going to be held liable. This is supplement under a trust agreement for the holding and developing of a parcel of real estate which requires beneficiaries to make such payments to the trustees so that there would be a full compliance with the terms and provisions of the purchase money mortgage, and which provided that beneficiaries could advance amounts due from any other beneficiary who failed to comply with his obligations. So they're paying for someone else, right? Under the trust, and in turn becomes entitled to a lien on the defaulting beneficiary's interest, because all you did was give him a loan. You didn't buy the title, but you are moving in on his property for sure because he owed a debt. So you get to put a lien on those shares. The beneficiary's interest could not be foreclosed for failure to share in the trust expenses, although such failure gave rise to a claim by the trustee against the beneficiary's interest in the trust, where the beneficiary was not in default on his obligation to pay his share of the cost of purchasing the land. That's some footnotes here. Nothing really worth mentioning. Those things in that chapter should be a given. Section 35, liability of torts. The beneficiary of an ordinary trust is not personally liable to third person. So they said ordinary trust. Right now, the business trust. For torts committed by the trustee. But in determining the liability of the shareholders of a business trust in tort, the court seems to apply the same test as the principles and in the cases involving liability on contract, the control test, meaning power in the beneficiaries to do something that they shouldn't, has been applied in this connection, and it has been held that the shareholders are personally liable for the torts of the trust where they are vested with the ultimate and effectual control over the business and property of the trust. This liability is to be noted depends upon the power of control and not upon the actual exercise. A fortiori, I forgot what this means, fortiori, up to now, up to this time, used to express a conclusion for which there is stronger evidence than for a previous accepted one. So better evidence shareholders in the business trust may become liable for torts or fraud of the managing trustee where they participate in or authorize them to be done. These annotations, these footnotes should be a given. I don't see nothing worth except specifics, conveying of land, certain lands, and stuff like that. Now remember the context and how they're being described as partnerships and the powers and stuff, right? The activities are going to be almost always different, from land to personal property, a business, so, some retail store, and it could be anything, natural resources. And those depend on a good degree too, on the activity, right? Like natural resources, like mining and oil. Section 36, nature and degree of control sufficient to impose liability. Under the control test, the character of an organization as a true trust or a partnership for the purpose of determining the personal liability of shareholders depends generally upon the powers vested in the shareholders by the trust instrument rather than upon the powers actually exercised by them. The fact that the agreement on its face provides for managers and not trustees is significant on, but not conclusive of, the question whether the instrument creates a true trust or a partnership or an agency. And the reason why it's on its face, right? If you delegate too much powers to these people right here, right? Especially if you give them more than ministerial powers, then you're creating some relationship with them, with the managers, for the trust. That's another relationship than what it is that you have them as just doing ministerial. Well, I guess there's always going to be a relationship. Just what type of relationship is going to depend on the powers. You could call them managers, but if you give them enough powers that they are considered trustees, well, what you're calling them means absolutely nothing. The determination of the question whether the shareholders have such effectual control of the organization as will render them personally liable generally depends on no single element of control. So not one thing. You know how earlier we were talking about what makes a corporation, right? You got 5 things that are basically the same on both sides of a corporation and a trust, right? But then now you have to add other characteristics of what a corporation is to your trust so that it will look like a trust. Same concept here. It's the exact same thing for a partnership. But they're telling you that no single one. So there could be 3 things as a given through its nature that are similar to partnerships and business trust. But on top of that, what did you do? What else did you add that are characteristic of a partnership that the one single element of control, you put on top of that and made you liable? And that's in here too. Circumstances held insufficient to impose partnership liability on shareholders include the mere power of shareholders to hold meetings. Right? So these are circumstances held insufficient. So that means these powers by themselves. So if you have 2 or 3 of these that they're fighting, what do you think is going to happen? Insufficient to impose partnership liability on shareholders include the mere power of the shareholders to hold meetings. So that means they get to call meetings. Occasional conferences about the affairs of the trust between the trustees and the shareholders who has no power of control. So you could call all the meetings you want, right? You just got to make sure that they have no control, that they're there just to soak in information about what you're giving them, and whatever the accounting is, right? The appointment by the trustees of an advisory board of shareholders where the trustees do not relinquish control over the affairs of the trust. And this right here is a protector. The appointment by the trustees of an advisory board of shareholders. Here, they're giving it a board of shareholders to do this, but you could assign and hire someone specifically for this. It doesn't have to be a board. You just can't give him powers because he's their representative. He's a protector is made there for you to make sure you specifically are doing your job. Your fiduciary duties are in line. There's no commingling of funds, and you're not what's that called? The way of doing business. I forgot. This right here is important, man, to understand that. Where the trustees do not relinquish control over the affairs of the trust, and the right to fix or control the minimum sale of price of lots vested in the declaration of trust. I want to see what this number 1 is. They don't give nothing, but they give a court case. Cray Packing versus Hitchin. It's a Missouri case. I should. Let me do this. I am going to look it up. Let's see what gives it like that. DLEX case text. Nope, that's not it either. This is the only one. This might even be the case. 18 Southwest 123. Yeah, alright, that's the case. I'll read it later. Let's see what else. Come back up here. As a general rule, the reservation, right? So this is powers. The reservation to the shareholders of a business trust of the power to elect trustees at stated intervals and to fill vacancies among the trustees resulting from death, resignation, or expiration of term of office. does not alone transform the organization into a partnership under the control test, so as to render the shareholders personally liable for the debts of the trust. Now, one thing you need to understand, this is American jurisprudence. They are talking about and have court cases here of every jurisdiction. It is up to you to find out if your jurisdiction doesn't see it that way. Federal for sure, but in terms of your state, every state is different. Everybody has their own internal revenue laws. And the same has been held true of the power to elect trustees in combination with other powers reserved to the shareholders. The vesting of power in the shareholders to remove or replace trustees has been said not to convert a business trust into a partnership, even in combination with the powers to amend the trust instrument and to terminate the trust. However, it has been stated obiter that if the trustees are subject to removal by the shareholders, right? So up here, they had that they could fill in vacancies. That's not removal, right? Are subject to removal by the shareholders and are dependent upon them for election, right? That's different too. Like you got to get a vote of the beneficiaries to get elected in. Dude, that's too much power on their side. To fill in vacancies has nothing to do with the trustees. That's just a power for them to fill in a gap. Here, this is putting it up for a vote, giving them a power. The ultimate control of the organization rests in the shareholders as to render them liable as partners. And the power of amending or terminating the trust has been held to give the shareholders such control as to characterize the trust as a partnership. The mere reservation to the shareholders of a business trust of a power to amend the trust instrument does not, of itself, convert the organization into a partnership so as to render the shareholders liable for the debts or the torts of the trust. And the power to terminate the trust has been held not to give the shareholders such control over the affairs of the trust will render them liable for its debts, even in combination with the power to remove trustees or with other powers reserved to the shareholders. However, the power to amend the trust or to terminate the trust, in addition to other powers reserved to the shareholders, has been held to render them liable. And this right here is all dependent on the cases, I swear. Because they're saying one thing, and literally the next two sentences they're saying that, okay, here's the opposite now. And that's literally the jurisdiction. No bull. But at the same time, right, if the power to, say, terminate the trust is a rare event, meaning the probability of it happening, like all trustees dying at the same time or in the same 30-day period, right? Dude, those are rare events that the court will not look at it in terms of a power that is at your will, at the shareholder's will as a given. And that's something important to remember. And I guarantee you read some of these cases that they're offering here, right? Will show you that they have it in rare events of certain things that the shareholders would be able to do. And it doesn't give them specifically direct power over the trustees. It says, for this footnote 17, it says, however, a provision of a trust agreement that the subscribers irrevocably nominate and constitute the managers, their agents, and attorneys, right, to do and perform all things necessary to carry out the contract does not necessarily indicate a relationship of partnership, right? And it's because they're their agents and attorneys for their personal self, that they hired them to act as managers, not specifically for the legal licenses or whatever organizations that they are in the capacity for their personal self. They are hiring them as managers. So as long as the powers and the indenture reflects that, then their other capacity, like us, right? We have the straw man capacity, right? Our individual private capacity and whatever, and our trustee capacity. It's all the same shit. It's all different contexts. So here, they're not held liable as partners because agents and their attorneys, their capacity in this did not apply to managers. That's how I would read it. Well, I did read this. So this is Darling case. So that's a partnership case. I'm not gonna read none of that. I'll let you guys debate to read some of that. I highly recommend it, no doubt. It's a lot of provisions. Yeah, I'll read this one. Where the trust instrument provided that property was to be conveyed to one of the subscribers in trust, that 3 officers and 3 trustees to be chosen annually were to have the entire management and control of the trust property and the business, that the business was to continue so long as the majority of the subscribers determined, and that the trust property might be sold whenever the majority in number and value so decided. In the power in the shareholders to amend the declaration of trust and to authorize an increase in the capital stock. That's a lot of power that they have. Section 37, provisions of trust instrument or contract negativing or limiting liability. And these are just provisions that you're supposed to write in your indenture and in your contract that you do contract with people. Stipulations affecting the personal liability of shareholders for debts or liabilities of business trusts are frequently found in the trust instrument. It is sometimes expressly provided that the shareholders shall not be personally or individually liable for the debts or liabilities incurred by the trustees or on contracts made by the latter on behalf of the trust, or that persons dealing with the trustees shall look for payment or satisfaction of their demands only to the property and assets of the trust, or that in every contract or obligation executed by the trustees they shall insert a stipulation exempting the shareholders from personal liability and referring to the trust instrument. So these are all great things right here. That should be a given. They give you footnote number 15. That's probably, yep, they give you a practice aid. Legal forms, American Jurisprudence, Volume 3, for both of them. And then they give you, oh no, that's section, that's footnote number 16. It is generally held that a provision of a trust instrument that persons dealing with the trustee shall look only to the trust fund and property, and that the shareholders shall not be personally liable, is not contrary to law or public policy. Can't be if corporations do it. If government and corporations do it, we for sure can. In a jurisdiction where the shareholders of a business trust are held personally liable for the debts of the trust, irrespective of the question of power of control, a provision of the trust instrument purporting to exempt them from liability has been held ineffectual. And it says the provision in the trust instrument, right? Not the contract. At least in the absence of notice to the creditor of the provision. So no notice to the creditor. According to this view, the members of such trust cannot confer immunity upon themselves by their own contract. In a jurisdiction following the doctrine that a business trust is, in legal contemplation, a partnership in the nature of a joint stock company, notwithstanding that exclusive control is vested in the trustees, it has been held that a provision of a trust instrument purporting to exempt the shareholders from liability for debts incurred by the trustees on behalf of the trust is invalid and ineffectual where there was no compliance with the statute relating to the formation of limited partnerships with respect to a creditor who dealt with the trustees with knowledge on terms of the trust instrument but without expressly agreeing only to look at to the assets of the trust. So he never expressly agreed. Where could a creditor only do that? In the contract that you signed with him. And these are the footnotes. These should be a given. Section 38, effect of notice or lack of notice. Where shareholders would otherwise be personally liable for the debts of the trust, it has been held in cases in which the question of notice has been considered that a provision of the trust instrument purporting to exempt them from such liability does not relieve them of liability to creditors, having no notice of such provision. It does not relieve them. So you didn't let them know. You ain't telling them the type of organization that you are. On the other hand, it is generally held that persons dealing with the trustees are officers of a business trust with notice of a provision of a trust instrument purporting to exempt the shareholders from personal liability for any debt or liability incurred by the trustees, or on any contract made by them on behalf of the trust, cannot recover against shareholders personally. Why? Because you contracted into it. The creditor in this case. Thus, where the trust instrument contained provisions limiting the liability of the shareholders, they have been held not liable to an attorney who performs services for a business trust with knowledge of the restrictive provisions, to a person who was put on inquiry as to the nature of the organization and the relationship of the parties connected therewith, or on a contract made by the trustees of the trust agreement purporting to exempt the shareholders from personal liability. Likewise, one who dealt with the business trust with actual notice of provisions of the trust instrument purporting to exempt the shareholders from personal liability for the debts of the trust has been held to be estopped to maintain an action against the shareholders on a note executed by the trustees. And that's the whole point. It stops them from trying to bring suit against the beneficiaries. That is literally the whole point of it. And they need to know that they can only look to that. You can't just sneak it into it and hope that they don't, you know what I'm saying? They have to know. They have to be, it's constructive notice, not just general notice. It's constructive notice. However, where all the shareholders were trustees, so that the trustees and the beneficiaries were the same persons, well, that's a no-no, right? Constructive notice imputed to a creditor of a trust instrument purporting to exempt the shareholders and the trustees from personal liability and to bind only the trust estate for the obligations of a trust was held to be unavailing to exempt the shareholders and trustees from personal liability in the absence of a contract to that effect. So there's no extra contract. But through the door, the fact that the trustees and the beneficiaries were the same persons, automatically you don't have a trust. You're a partnership or something. You're already through the door, you dead. So these are the footnotes. Persons employed by the executive committee of a trust acting within the apparent scope of its powers as agents for the beneficiaries are not precluded from recovering their commission from the beneficiaries by a limitation in the trust agreement upon the liability of beneficiaries where such persons had no notice of limitation. Same thing. They weren't given that notice. And then that's what it is. Write it in your document and give them notice. Sufficiency of notice. Section 39. A mere reference to the declaration of trust or a recital that the contract is made by the trustees pursuant thereto has been held to be sufficient to charge the contracting party with notice of a provision of the declaration purporting to exempt the shareholders from personal liability. The statement by an officer of the trust at the time of entering into the contract on behalf of the trust that the organization was not a corporation and that he thought it was a partnership has been held to be sufficient to put the other contracting party upon inquiry as to the nature of the organization and the relationship of the members thereof. However, the fact that the president of the creditor bank was one of the organizers of the trust has been held not to charge the bank with notice of the limitations in the trust instrument upon the personal liability of the. But even this right here, right? It doesn't matter if the bank, the creditor, worked for the bank or not. That wasn't notice. It wasn't filed in no paperwork for the bank to have that notice. The question whether persons dealing with a business trust are charged with notice in trust instrument stipulations relieving shareholders of personal liability by reason of recordation or the trust instrument is discussed elsewhere, and that's discussed in section 4, I think, above, right? Section 16. Here are the footnotes for this section. Where a note executed by trustees recited that the undertaking was by trustee as such under a certain declaration of trust and not otherwise, and the declaration of trust exempted the individual shareholders from liability on any contract or undertaking, it has been held immaterial as regards the liability of shareholders on the note, whether or not the plaintiff examined the declaration of trust or knew of its contents, since the provision in the note required him to do so or to take the hazard if not doing it. You know what I'm saying? This is it right here. He was told to and then chose not to. You can't, make that up. That's like a given. I don't know. So section 40, contractual limitations, recitals, and references. Generally, and even in a jurisdiction holding ineffectual a mere provision of a trust instrument purporting to exempt shareholders from personal liability for the debts of the trust, it is competent for the trustees and persons dealing with them to stipulate for the exemptions of the shareholders for liability. Where the creditor agrees that the shareholders shall not be personally liable, no recovery can be had against them. And such an agreement is valid and binding and violates no public policy. So if there's a public policy where beneficiaries of a trust can be held liable as partnerships as a given, right? Okay, well, the contract changes that, and it doesn't violate the public policy either. And that's the difference. One is general, one is specific, where someone is contracting into it and agreeing to it. And a statute describing the manner of the formation of limited partnerships does not invalidate such an agreement. It is not necessary to exempt the shareholders from liability that the agreement to this effect be expressly stated. The agreement and understanding to this effect may be implied in fact from the circumstances. The parole evidence is admissible to show an agreement or undertaking between the contracting parties that shareholders shall not be personally liable on an obligation executed by the officers of the trust. And that should be a given. Like, if you don't have paperwork that says that they're not supposed to be liable, and your trust is based on verbal contracts, well, in the end, no matter what, you still have to show somehow, some way, through evidence, parole evidence, witness testimony, affidavits, you name it, that they are not liable for however authority that person has to state that. In other jurisdictions, a mere reference in the contract to a trust instrument has been held sufficient to exempt shareholders of personal liability on the contract where the trust instrument contained a provision to the effect that the shareholders should not be held liable. Case authorities supplement provision in a loan agreement between business trust and debtor, by terms of which debtor had specifically agreed that it will look only to the property of the trust for enforcement of any claims against the trust, and that the individual shareholders would not be liable for such claims, was valid and not against public policy. This is a loan agreement. Now, do we know who is who? Who made this loan agreement? The business trust or the debtor? Well, I guess that kind of answers it in itself. I won't go through these annotations. I'm hoping you guys do. This right here is section D now. This is rights and liabilities inter se. Inter se means amongst themselves. So since this is the shareholder section, this is the rights and liabilities amongst themselves. Where only the rights of shareholders and trustees among themselves are involved, the court will, as far as possible, give effect to the provisions of the trust instrument. As between the parties of the trust instrument, a provision therein exempting the shareholders from personal liability is valid and binding. Such a provision is binding upon the shareholders who are charged with knowledge thereof, and the same is true as between the shareholders and an officer or a trustee of such a trust. The trustees cannot, for their own benefit or protection, assert the liability of shareholders where such liability results from the failure of the trustees to perform their duty to insert in the contract made by them the provision exempting the shareholder. So say you fuck up and you forget to write that provision in your contract. Well, the shareholders can't come after you and attack you. They just can't. And you got to read this case to find out specifically why, right? But they're telling you here that they can't hold you liable for failure for you to write that provision. I would try to prove this provision correct, even though that's not in the contract, by other circumstances and scenarios or paperwork that you might have to show that this trust has never dealt in such a way that would make the shareholders liable in any way, and to the effect that even the trustees don't have the power to do that. It's one thing stating it, that they have limited liability. It's another thing that you, as the trustee, cannot bind them either intentionally or not, right? It has been indicated that where the trust is treated as a partnership, the claim of one shareholder against the others as partners can be asserted only in an accounting proceeding, and that until there has been an accounting and settlement of the partnership affairs, a shareholder cannot recover against the shareholders on a contract between the former and the trust, especially where the trust instrument expressly exempts shareholders from personal liability. Where the organization is in legal contemplation a partnership, the several shareholders sustain to each other a fiduciary relation which is violated by the acts of one shareholder in making a secret profit from a transaction which is ostensibly, meaning out just showing, he's blatant about it, between the third person and the trust. And in case involving a trust of this character, it was held that the three corporations which owned the majority of the shares of the trust could not, against the objection of the minority shareholders, authorize at the shareholders' meeting held pursuant to the trust instrument the sale and convenience of all the trust property to such majority shareholders. So they were trying to sell the property of the minority against the minority to what the majority wanted. However, there is authority for the view that the shareholders of a business trust do not bear any contractual or fiduciary relationship amongst themselves, which is true. Also, it is competent for the trust instrument to provide against any fiduciary relationship as between shareholders, right? So this is you, in some way, as a trustee, to step in, right? It is competent for a trust instrument to provide against any fiduciary relationship as between. As I gotta read that case too. But that's, the gist of it. It gotta be provided. Something gotta be provided for any argument between them. Doesn't necessarily have to be a fiduciary though. The protector has similar duties, but they're not fiduciaries unless you make them that. All right, I'm not gonna read the footnotes. Let's see. Section 42, contribution. Where the shareholders of a business trust are personally liable for the debts of the trust, one of them who has been required to pay such a debt may enforce contribution from the other shareholders. The estate of the deceased shareholder has been held liable for contribution on account of a debt incurred and paid after his death. It would appear, however, that the liability of shareholders to contribute is only for the proportion of the debt represented by their proportionate interest in the shares. So if you're selling shares, right, and the shares are worth 1,000, and they're doing payments of $100 every month or something, right? Well, they could only, the maximum they could ever you could force them to contribute is their 1,000. And where contribution is sought for a judgment paid by the shareholder in another state, it has been held that shareholders who were not parties to the action are not concluded thereby. That's a given. The right to contribution may, of course, be affected by equities among the shareholders themselves if their liability resulted from the personal fault or neglect of the shareholder seeking contribution. The other shareholders cannot be compelled to contribute. Thus, where the liability of a shareholder for a debt of a trust results from his failure to insert in a contract executed by him on behalf of the trust a provision exempting the shareholders from personal liability, as required by the trust instrument, he is not entitled to contribution from the other shareholders. Under the provision of a trust instrument that the decease of a member should not dissolve the trust, nor entitle his representative to take an accounting or other action in court against the trust or the trustees, and that such representative should simply succeed to the right of the deceased to the shares, subject to the declaration of trust. And this is absolutely true. Just the death of a member, trustee too, right, doesn't give no power to no one to do anything, to ask for anything or, whatever. So his executor, right, managing his estate after the death or whatever, he only has the right to succeed to the shares that are governed by law, like heirship or a will or whatever else. That's it. And those are provisions that one should have. All right, well, that'll be it for this round. This is part 5, subpart 2, right? Next section will be about the trustees, officers, and agents. And damn near everything that we just read about the shareholders will apply to them too, in terms of liability and stuff. All right, so that should be understood too. All right, and that'll be part 6. So again, for those that are interested, I will be doing a video on this elementary law, right? For sure, that's a YouTube video. If you guys want me to do a webinar, right, then I'll do this one on foreign estates, income tax on foreign estates and trust and stuff like that. But this has to have interest in it. People need to want to participate for me to want to do this. And you guys will get the PDF afterwards. All right? And that'll be it. And until next time, have a good night and Happy New Year for sure.